Merci beaucoup, Monsieur le Secrétaire Général, de vos paroles.
Thank you very much, Mr. Secretary General, for your kind words of introduction. As time is short, I will therefore start without further ado, after pointing out that I feel very strongly the honor of giving this inaugural lecture to open this session, and the great pleasure that I have in being here in the presence of students. The subject I have chosen is therefore private international law and international commercial arbitration. And I said to myself afterwards that in this high place of public and private international law, that is the Academy of International Law, it was perhaps a little presumptuous to place international commercial arbitration on an equal footing with private international law, even if private international law was placed first in the title. The traditions that delimit private international law are not the same in all countries. In some countries, international arbitration is included in private international law. Elsewhere, it is left outside, sometimes in splendid isolation. Sometimes it is drawn into the field of international commercial law. These are basically academic distinctions, which are not of great importance, but which nonetheless point to us that today the law of international commercial arbitration is perfectly known, identified, that it is of great interest, and that obviously it is not uninteresting here to question its relationship with private international law. But much more important than the point of view, the division of academic disciplines, what is much more important is the fact that the disputes that make up the fabric of international commercial arbitration are all made up of a subject that in itself is indisputably a matter of private international law. International commercial relations, especially contractual relations between private or possibly mixed persons, clearly fall within the field of private international law when, because of their internationality, they give rise to conflicts of law, they raise a problem of determination of jurisdictional competence, or the international effectiveness of the decision obtained. I would say that all the markers of private international law are basically mobilized in international commercial arbitration. But once again, given what has become of international commercial arbitration, one should not think today of a real absorption of it into private international law. This is because international commercial arbitration today has become a real institution, an institution that acts as a screen between the operators of international trade and private international law, whose rules would be applicable if international commercial arbitration did not exist or were not present. In other words, it interposes itself between international legal situations and national jurisdictions from which it steals, so to speak, jurisdiction. So it's an institution that cannot be ignored. And then, if we look at it from the point of view of its function, things are simple. International commercial arbitration has full jurisdictional function. Of course, it is a jurisdictional function which is not exactly exercised under the same conditions as that of state courts. Here, we're talking about a jurisdiction that is rather private in nature, which is rather transnational. It's a justice that is external, as it were, to the justice of the state. And therefore, ultimately, international commercial arbitration appears sometimes as an institution and sometimes as a court. And it's from these two standpoints. This is the guiding thread that I will follow in order to outline before you, obviously, the relations that do not fail to be established between arbitration and private international law. I will therefore start with international arbitration, considered as an institution. The place currently occupied by international arbitration as a means of settling disputes and international economic relations leads us to see it as a real institution. The use of the term institution might be astonishing, perhaps, for a form of justice, one of the fundamental characteristics of which precisely is that it is not institutionalized. Admittedly, international arbitration was not conceived, was not built as an institution, but it has become one. It has become one under its own dynamism and also by virtue of the very favorable context in which it has developed for more than 50 years now. And if one considers, according to a classical definition, that an institution corresponds, and I quote, to a socially established and legally sanctioned practice, then arbitration is indeed an institution. It is established in a social field within which its very particular purpose to settle disputes, not on behalf of the state, is recognized and integrated by the legal orders with which it comes into contact. And under such conditions, it is legitimate to expect that private international law will play a certain role in the establishment of this institution. However, the singularity of international arbitration has led private international law to favor its less usual methods, leaving, what is more classic, the question of conflicts of law a little on the periphery of the construction of this institution, which is international commercial arbitration. So let's start with this rather unusual method, conventional method and material rules. The functioning of international arbitration is hampered by two obstacles that absolutely had to be overcome, failing which its development would have been irredeemably compromised. As you know, the basis of the jurisdiction of arbitral tribunals is based on an arbitration agreement which is concluded by the parties. Arbitration absolutely needs the broadest possible recognition of this arbitration agreement. Only such recognition is likely to lead to the withdrawal of the state courts when the latter would have jurisdiction over the dispute which is entrusted to an arbitral tribunal. This was the early objective of the Geneva Protocol of 23rd of September 1923 on arbitration clauses. And the second obstacle standing in the way of the development of international arbitration is that of the international effectiveness of the award. And this was the object, to obtain the international effectiveness of the award, of the Geneva Convention of the 26th of September 1927 for the enforcement of foreign arbitral awards. The United Nations Convention of New York of the 10th of June 1958 rendered these two pioneering conventions obsolete. You know its title, Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Its title indicates that it focuses on enforcement abroad, but the title is misleading. Article 2 of the New York Convention is devoted to the recognition of arbitration agreements. So, in this end, this convention has superseded its two predecessors by encompassing the two objects that they each dealt with separately. It has modernized the applicable rules and increased the favor of arbitration. Its success is considerable. As you know, that it has now been ratified by more than 150 states. And I will simply mention alongside the New York Convention, which is much less important but nonetheless very interesting, the so-called European Geneva Convention of 1961, which had influence but which addressed with great perspicacity some of the issues which were not directly within the scope of the New York Convention. Thus, the conventional route was favored, and it brought with it the use of the method of substantive rules in a very largely or a very predominant way, and therefore to the internationality of the matter known as international arbitration correspond the substantive rules brought by the conventions and which provide the specific solutions which seemed indispensable and best suited to the authors of the conventions. Nonetheless, none of the existing conventions at present sets out to deal with the whole of the arbitration matter. Each one is limited to its own subject matter, and many important questions of arbitration law are left aside. Under these conditions, it is not surprising that for those countries most interested in promoting arbitration today, who is not interested in promoting arbitration, it appeared necessary to complete, as it were, the work that had been initiated at the level of the international community by the adoption of arbitration laws or by the modernization of archaic laws for those that had laws dating back to the 19th century in general. Thus, over the past 40 years or so, numerous laws relating to arbitration, both domestic and international, have been added to the international conventions left as they stand because it is so difficult to revise an international convention that, for the time being, no one has ventured to try to touch the New York Convention. So there are a lot of national laws on arbitration today. Do these national laws ultimately provoke conflicts of laws that would be damaging in themselves to the establishment of an international legal corpus necessary for the development of international arbitration? Firstly, let's say that conflicts of laws in this area are very limited for two reasons. The first reason has to do with the existence of the UNCITRAL Model Law, the United Nations Commission on International Trade Law, which dates back to 1985. The model law was the instrument of an ambition that was perfectly suited to the needs of the time, since international arbitration was really starting to take off in the 1970s and 1980s. The world did not need to increase the diversity of regulations with enthusiasm or confusion, but on the contrary, needed to achieve, if not unification, at least harmonization of regulations. That was the purpose of the model law. It did not aim at completeness, it did not claim to be perfect, but it tried to find the most suitable common denominator so that as many countries as possible would not deviate from the canons of international arbitration, such as it had been shaped by model law. And so, by homogenizing arbitration law, the model law has thus made the real conflicts of laws, to use an American expression, that a number of you may be familiar with, less common. The second element that makes conflicts of laws in arbitration rare is the choice of the connecting factor. It is generally asserted that the laws of states that are devoted to arbitration are applicable to arbitrations according to the place where the seat of the arbitration is established. Since each particular arbitration has a single seat, the seat of arbitration determines the applicable arbitration law. The seat would thus be a connecting factor in the eyes of a bilateral conflict rule according to the dominant model in private international law. Thus, each particular arbitration procedure would be located at the seat of the arbitration whose law is applicable to it. This presentation, which is the presentation which is generally made, is not false, of course, but it seems to me, nonetheless, to take many liberties with reality. The vast majority of arbitration laws applicable to international arbitration do indeed contain a substantial provision setting out their scope of application in space. And to this end, they almost systematically refer to the seat of the arbitration, saying that they are applicable in international matters and to arbitrations whose seat is located in the territory author of the regulation. So you can see, if you're familiar with private international law, that in reality these provisions correspond to the model of the unilateral conflict rule and not to bilateral conflict rules. The result is not very different, but we note nonetheless that no bilateral rule has ever been enacted in this area by any state. Thus, there is a kind of bilateralist, conflictualist saga that unfolds when reading arbitration laws, and whose completion is to be found in the use of the concept of lex arbitri. The lex arbitri, a Latin word which brings with it a certain majesty, is reminiscent of the lex contractus. The law applicable to the contract corresponds to the name lex contractus. In international arbitration, therefore, the applicable law would be the lex arbitri. However, I believe that on the subject of the lex arbitri, whose interest and existence should not be called into question per se, we must nonetheless show a little modesty, because, if you like, it seems to me that to say that international arbitration, that each arbitration is subject to its lex arbitri, is a little too small a suit for international commercial arbitration, and there are three reasons for this. The first reason, first of all, it should be recalled, is that international arbitration has never been considered as a subject of regulation that should leave a blank check to national legislators. The role of international conventions, as I have already mentioned, provides evidence for this. It follows from the 1958 New York Convention that the law of international arbitration is clearly based not on the determination of the national law to which each arbitral procedure will be subject, but on a system conducive to the effectiveness of arbitration, the main lines of which are drawn by the substantive rules deriving from the treaties. Second reason, the objective thus defined is therefore that the functioning of international arbitration should neither be hindered by borders nor disrupted by the diversity, be it moderate, of the applicable national laws, and the preferred means which is chosen in the first place in order to satisfy this objective is the setting up of an international system of coordination between the state legal orders with which each arbitration procedure comes into contact. And for the New York Convention, as I have already said, this coordination takes place at two levels. Firstly, the level of the arbitration agreements, and secondly, the level of the effect and international effectiveness of the award. We can therefore see from the second observation that the mission entrusted here to private international law is not at the level of conflicts of laws. Rather, it is a matter of private international law through its conventional law branch to structure arbitration flexibly in its international configuration, and not to bind it under the law of a state or to confine it under the law of a state. Conflicts of laws under the New York Convention are thus secondary. They do not form the backbone of the system that is put in place. And this is in line with the implicit recognition that international commercial arbitration is a genuine institution capable as such of ensuring its own functioning, and whose task is merely to establish, at best, the best possible relations with the legal orders with which it inevitably comes into contact. Coordination is almost tripartite between one state and another state which has a link with arbitration and the institution of arbitration itself. Third observation on this point. In actual fact, there is an arbitration lexicon applicable to each arbitration procedure, if you like, but it seems to me that we must admit that arbitration is not international arbitration, cannot be the subject of a true mono-localization, but that it is the subject of a pluri-localization. Hence, the lex arbitri is therefore the dominant but not exclusive element of this pluri-localization. And it has to be admitted that in international arbitration, there are two irreducible poles of attraction which are apparent. There is the seat of arbitration, Basically, we took the seat instead of. We should have taken the agreement. The most interesting thing is the agreement and the award, but you can't solve a conflict of laws problem by taking an agreement as a connecting factor. It's too mobile. So, since the our agreement could not be taken as a model, we went to the seat of arbitration. That is what plurilocation is all about, the seat of arbitration, which brings with it the determination of the lex arbitri, which has the advantage of setting the legal framework of the arbitration at the beginning of the proceedings. And when we arrive at the award, almost all the arbitration is embodied in the arbitral award. The lex arbitri is lost sight of. What matters is the law of the country of enforcement, except on the question of annulment. So, to conclude this first part, I would say that faced with international arbitration, private international law, as we have seen, has deployed the means that were necessary without abusing them. Faced with an institution which has not always imposed itself without encountering resistance, but which today has become unavoidable, arbitration, private international law has accompanied it more than it has sought to obtain its submission. And the result of this mode of intervention seems very positive to me. The New York Convention has created the legal biotope that is essential for the international arbitration to flourish. Conflicts of law, which fortunately have been avoided, have left the field open to substantive rules deriving from treaties as well as from national laws, established in a collaborative spirit and therefore rather universalist than nationalist or particularist. Thus, the institution of international arbitration confirms its existence, proclaims and demonstrates its autonomy, which is absolutely crucial to the function of transnational justice that it intends to fulfill. Let us now turn to the second aspect of arbitration. Arbitration no longer seen as an institution, but seen functionally from the easier to conceive angle of a jurisdiction. If we consider international arbitration as a jurisdiction, therefore in its jurisdictional function, I think that the first point for us will be to situate this jurisdiction in the concert. It must fit into the concert of state jurisdictions. Then, once the award has been made, it is important to know, and here again private international law will have its say, what will be the fate of the award and its international effectiveness. And here, the means of appeal are of considerable importance. Finally, but here I will not focus on particular arbitration as seen in respect with state courts, but from the point of view within the arbitration seen from the side of the arbitrators. Will the arbitrators not have to apply private international law themselves in the application of their mission? Will it be the same way as judges, or will there be reason to believe that the private international law of arbitrators is not exactly the same as that of judges? Let's start with the inclusion of the arbitral tribunal in the concert of courts. International arbitration thus presents itself as offering an additional possibility to parties who might have an international commercial dispute. Not only can they bring their case before a state court, which they may have chosen by a contributory clause conferring jurisdiction, or which will be imposed by rules that have regard to the objective links between the case and the court, or the parties may choose international arbitration. But the whole problem will be how this jurisdiction of the arbitral tribunal will be articulated with that of state courts. It appears as a kind of black sheep amongst white sheep, this arbitral tribunal. Is it going to be easy to fit in? First point. The basis of arbitral jurisdiction will not retain our attention for long, since the issue is well known even to non-specialists in arbitration law. You know that the basis of the jurisdiction of an arbitral tribunal is the will of the parties expressed in the arbitration agreement. I stress that this voluntary basis excludes any other basis. Contrary to what happens in the case of state justice, there is no objective ground of jurisdiction in favor of international arbitration. Here, jurisdiction does not pre-exist the dispute. On the contrary, it is the dispute that gives life to the jurisdiction. And for this, the consent of the parties is indispensable. This movement is amplified by the material rules which favor the effectiveness of the arbitration agreement, such as the famous rule, the famous principle of the autonomy of the arbitration agreement in relation to the main contract. So much for the foundation of arbitral jurisdiction, which tells us that there is a possibility. But how will this possibility of inserting arbitration amongst the state courts play out in practice? In practice, a difficulty arises because we are going to have to proceed to the actual articulation between an arbitral or arbitration procedure and a state procedure. The problem does not arise when parties agree on jurisdiction, but frequently the parties disagree on jurisdiction. And therefore, if they disagree on jurisdiction, for example, because one of the parties claims that there is no need for arbitration, because the arbitration agreement does not exist, or because the arbitration agreement has not been transmitted or is not applicable and does not cover this kind of dispute, or even because it's not valid, we therefore risk having a conflict between the party which wishes to submit dispute to the state court and the party which wants to bring the dispute before an arbitral tribunal. Where is the problem of private international law here? The problem with private international law is that the jurisdiction of the state court depends on the rules of private international law. The competence of an arbitral tribunal depends on the rules of arbitration law. But we can see that when there is a dispute, we are at the crossroads between two universes. So how can it be settled? This is settled by means of an absolutely fundamental rule, which is already to be found in the UNCITRAL model law in Article 16.1, the well-known principle of jurisdiction to decide jurisdiction. This principle of jurisdiction to decide jurisdiction has been placed on the side of arbitration law. It has two sides, a positive side and a negative side. On its positive side, this principle gives the arbitral tribunal the power to rule on its own jurisdiction. It is a power that seems perfectly justified. It is the prerogative of any judge, and the arbitrator, at least functionally, is a judge. Therefore, by declaring itself competent, the arbitral tribunal affirms its jurisdiction and at the same time probably neutralizes the potential jurisdiction that a state court would have had. But this neutralization does not pose any problem because, as we have observed, the very existence of the arbitration agreement has done away with state jurisdiction. So there's no problem at that level. But the principle of jurisdiction to decide jurisdiction also has a negative side. This negative side means that this principle does not only play out in front of the arbitrators, where the arbitrators apply it positively to say, are we or are we not competent, but it also extends as far as the state court, which would be seized by challenge of the arbitral jurisdiction. And this negative phase, if we follow it, will simply prevent judges, the court and the state court, from ruling on arbitral jurisdiction. So, as you can see, the negative side of the principle of jurisdiction to decide jurisdiction gives an extension of the principle that played out before the arbitrators by preventing the judges from ruling on the problem that can be exclusively settled by the arbitral tribunal itself. This principle can be applied in both cases that may be faced. The state court has been petitioned first. The arbitral tribunal has not yet been petitioned, or the arbitral tribunal has been seized first and the state court seized second. We have two courts then that are petitioned at the same time. The whole point of the principle of jurisdiction, of the negative effect of jurisdiction, is that it absolutely refuses to give the parties who would like to challenge the arbitral jurisdiction a means which is very often used in a dilatory way, seeking delay. Arbitrators, being judges, are a priori supposed to be perfectly capable of judging their jurisdiction, and one realizes that challenging the arbitrator's jurisdiction is often done wrongly or even in bad faith. So the idea is to leave the arbitrators, with a few rare exceptions, the possibility of imposing the solution themselves about their own jurisdiction, and the state court may only intervene at the very end of arbitration if control, say, is exercised over the arbitral award. This negative principle of the jurisdiction to just decide jurisdiction is not universally accepted. Far from it. Its origin is French international arbitration law, which, as you know, is very advanced in the field of international arbitration. Switzerland is not far from joining it at present, and India has recently joined it. Nonetheless, many countries level criticism at it, considering that it is simpler to leave it up to the judges to decide on arbitral jurisdiction. It is possible that this might be of interest in a number of cases, but nevertheless, one may have doubts about the universal value of the position of a judge who would say, I am competent in a case, although there is an arbitration agreement. Does that mean that the arbitration agreement, for all that, has no validity and cannot be used? No, especially since the judge will almost often not have said that the arbitration agreement is annulled. So the solution still seems a useful and good one, and is in the process of being extended. I have to say that recently there may have been concern at the EU because of a judgment of the Court of Justice of the European Union in West Tankers, the West Tankers judgment of the 10th of February 2009, in which there was a problem of anti-suit injunction, problem which we absolutely cannot delve into here, but in which basically you had an arbitration procedure against a party who argued that a case fell within the jurisdiction of an Italian court, and the Court of Justice, which was asked for a preliminary ruling, held that the European courts, if their jurisdiction was challenged on the pretext that there was an arbitration clause, should above all decide the matter themselves without giving the arbitral tribunals the opportunity to do so. The West Tankers judgment is not and cannot be considered at present in Europe as having established definitive and indisputable case law. We very much hope that this is not the case, as this would be disastrous for international arbitration. The second point I'd like to turn to now is the architecture of appeals against the award, assuming that we have reached the end of arbitration, that the award has been made. As you know, once an arbitral award has been delivered, there are two possible types of recourse. There is either a direct appeal against the award in the country of the seat of arbitration, or an indirect action against the award in any country in which a party, the winning party, avails itself of its award to request its exequatur. The system for the recognition and enforcement of arbitral awards, as you have already understood, found its primary solution in the 1958 New York Convention. The system, I won't go into details, is not very different from the system we're familiar with in private international law with regard to the effect of foreign judgments. The spirit is more or less the same. However, rules have simply been adapted to arbitration, since arbitral justice is not rendered under the same conditions as state justice. The questions that arise are not all identical, but the mechanism, roughly speaking, is the same. It can therefore be said here that private international law has inspired the law of international arbitration, or, as it were, that it has adapted itself to the law of international arbitration. Now, The same thing doesn't quite hold true for cancellation or annulment. The annulment of a state court decision, as you know, can only take place before a higher court in the country in which the court intervened. And the annulled decision is thus deprived of any effect, both in its original legal order and in any other legal order. It is a question of the distribution of jurisdiction based on the sovereignty of states. There is no difficulty or discussion. But unfortunately, the system is not the same in international arbitration. You can't apply the same principles to arbitral awards. Except in ICSID arbitration, there is currently no international or transnational system of setting aside awards. The setting aside of arbitral awards is therefore done before a state court, which exercises a kind of functional duplication, and the state court, which will have jurisdiction to set aside awards, as you know, is a court of the country of the seat of arbitration. So we therefore end up with a system which can be simply presented, which seems to be simple, clear, and rigorous. The annulment decision acquires, if it's rendered in one country, immediately a systemic scope, which is specific, and the annulment judge in the country of the seat of arbitration has exclusive jurisdiction and his decision has global effects. So it's a system based on a certain conception of the relations between state justice and arbitral justice. There is nothing absurd therein, but we can see that over the past 15 years or so, basically the consensus that existed in this respect has been broken because of the resistance existing in a number of countries, France, the USA, Belgium, and the Netherlands, for example. There has been some resistance to the idea according to which when a decision to set aside an arbitral award has been taken in one country, it is automatically binding on all other countries. And there are several reasons that have been given for that. I can't go into them in detail, but sometimes the annulment is given for a purely local reason, which does not seem to be clearly internationalized. So at the moment, the situation, I believe, is as follows. And you will see that private international law and arbitration law are sometimes in opposition. You therefore have a first possible solution, which is the one I've just described, the clear and dominant system in which international arbitration with a certain conception, annulment, is imposed throughout the world. The award that has been set aside no longer exists. It no longer exists for anyone, nowhere. Second, you now have a second stream. The current of resistance, the hardest, is the one that comes from France. The one consists in saying that since an arbitral award is never integrated into the legal order of the state, the annulment has no effect abroad. Therefore, it is permissible in France to give exequatur to an award that has been set aside in a foreign country. The French solution has so far been presented as a solution without any nuances. I'm not sure that in the years to come certain nuances will not appear, but for the time being it appears unqualified. So let's say it is the second position. This is the hard position. Then there is a third position which has appeared. It appeared here in the Netherlands from the Supreme Court of the Netherlands. It consists in trying to solve the problem by resorting exclusively to private international law, saying, after all, if we want to know whether we should give effect to a regulation that has taken place abroad, let us ask ourselves whether the decision to annul is it a decision that, according to the rules of private international law, would be binding in our country or not. And so we look at whether the decision to set aside could have effect in the country where the award is invoked or could not have effect. So we have three systems, and at the moment we have a kind of schism. The problem is not solved in international arbitration. It will be discussed for a long time, and we may possibly never have a unitary solution. One question to conclude on this point. What does the New York Convention say? The New York Convention does not actually say much, finally. It did have regard to the fact that an award may have been suspended or set aside abroad, but it did not make it mandatory not to give effect to that award. Moreover, the New York Convention in Article 7 allows all countries that wish to do so to have more liberal and favourable rules for the enforcement of awards. That is why in France we say we apply Article 7, and therefore, as we do not have in our arbitration law the case of the annulled award, we continue to give effect to an award that would have been annulled abroad. Finally, I come to the last question, that of conflict of law settlement. We're changing slightly our perspective. We're now before the arbitral tribunal, and the arbitral tribunal, like any court, is faced with a conflict of laws it must resolve. So, how is the arbitral tribunal going to reason? Is it going to apply private international law in the classical way? I think not, but I believe that to explain this, two observations are warranted. And having made those two observations, I will draw the necessary consequences. First observation. International arbitration is contract based justice. This is obvious, you already know that. But the contractual basis of arbitration, as we know, manifests itself, first of all, in the fact that arbitration is a justice chosen by the parties by means of an agreement. But it goes even further. The contractual aspect of arbitration also manifests itself in the contractual organization of the arbitration between the parties and between the arbitrators and the arbitration institution. The purely contractual basis of the whole arbitration can therefore be seen as an immediate consequence of this situation. It is possible to conceive, as an immediate consequence of this situation, the universally widespread recourse to the principle of autonomy of will, on the question of the law applicable to the substance of the dispute as well as to arbitration proceedings. So, of course, one might object by saying the principle of autonomy is the applicable law, the conflict rule applicable in matters of contract. There is no reason why, in matters of arbitration, the principle of autonomy, which is perfectly justified before the courts, should not apply to international commercial arbitrators. I'm not saying the opposite. Of course, the conflict rule principle of autonomy is fully justified before arbitrators and judges alike. What I'm simply saying is that the global contractualization of international arbitration means that the principle of autonomy is at a higher level for it than the conflict rule. Therefore, it is totally arbitration itself in which the parties can decide the law applicable to disputes, regardless of whether or not there is or would be a conflict of laws with regard to the contract. So the principle of autonomy plays, but it plays here as a rule of arbitration more than as a rule of conflict. The second principle I would like to mention, and I will go very quickly, is the fact that international arbitration has no lex fori. No lex fori in international arbitration. We know that international commercial arbitrators do not have a lex fori. The lex arbitri is not the lex fori. The lex arbitri is the law applicable to international arbitration. The lex fori is the law of the judge, or it would be the law of the arbitrator backed by a legal order that is binding on him. However, the arbitrator, when exercising his function as an arbitrator, does not have a legal order that is binding on him. He does not have a lex fori, and therefore he has no conflict rule, no laws that are binding on him. This is very clear when we look at Swiss international arbitration law, because Switzerland is a country that is very much in favor of the lex arbitri, but which nevertheless demonstrates that it is not in any way requiring arbitrators to use the lex arbitri as the lex foris. So the consequence of this state of affairs, and I'll conclude very quickly on this point, is that in terms of the settlement of conflict of laws in arbitration, the principle of autonomy, where applicable, and for this purpose, it suffices to read in an arbitration law or an institutional arbitration rule the question of the law applicable to the substance of the dispute. The principle of autonomy plays in a refined way in relation to what it is in national laws, in the conflict of laws rules, and it generally opens up to much greater possibilities for the parties, in particular, to apply not only the law of one state, but to apply rules of law, whatever they may be, as regards objective location. objective application of the law, where there is no choice by the parties. Again, when you look at the law of arbitration, you have a rule which seems rudimentary, but which gives the arbitrators every possibility to determine by practically any method the law applicable to the substance of the dispute, where the parties once again have shown no willingness to do so. This is a far cry from the very elaborate and rather complex conflict rules found in the European Regulation on Conflict of Laws in Matters of Contract. And the only thing that can be a problem for an arbitral tribunal, the rest is not a problem, is that it does not have a system of conflict of laws that is imposed on it, and therefore the general rules of conflict of laws that are generally found, well, they don't know exactly where to find that, but there is sometimes less need for that. Take the qualifications. There is no legi fori qualification for an arbitrator, but this is not very serious because very often an arbitrator does not need to qualify, since the very choice of law left to the parties does not lead to qualification issues. Second issue, the status of foreign law. There is no foreign law before arbitration tribunals. All laws are foreign, and therefore there is simply a problem of content, of determining the content of the applicable law, which is settled in a rather different way from the way it is settled before the judges, before the courts, but we are beginning to know how to do this. And the third issue is international public policy. Logically, the international public policy of an arbitral tribunal is only the transnational public policy. In the end, as you can see, the private international law that is applied by the arbitrator is subject to serious distortions, and you can imagine how much private international law, as we know it, and as it will be taught to you here, depends on the presence of the state and its justice. At the level of transnational justice that arbitration represents, private international law appears to lack a backbone, to some extent decentralized, without the presence of a state legal order of reference. And hence, almost inevitably, the idea of a strong substitute arbitral or arbitral legal order for the most daring almost invariably comes to mind. Thank you very much.